What are the actual things that we need to look out for when conducting corporate due diligence when buying a business? First, as discussed, you'll want to make sure that these sellers own the shares. Now, this sounds obvious, but you'd be surprised how often there are discrepancies. You need to verify that each seller is recorded as the legal owner of those shares that they're selling. So you want to check the company's register of members, the statutory registers, and compare this with the information that you believe to have from the sellers and that which is held at the company's house. If there are any mismatches, make sure to investigate them before you proceed. Secondly, you'll want to check preemption rights. So preemption rights give the existing shareholders the right of first refusal when another shareholder of the company is transferring or selling their shares. So this is going to be especially relevant, of course, if the company that you're looking to buy has more than one shareholder. And if not everyone is on board with you becoming the owner of the company, then that might create problems. These restrictions are typically found in the Articles of Association that are accessible via the company's house profile, or even in the shareholders agreement between the shareholders, which is not publicly available, and you'll want to request a copy of from the shareholders. If there are preemption rights, then the other shareholders will need to waive their preemption rights. You'll need to have waivers in the SPA, and if necessary, we might need to follow the relevant process as is typically detailed in the preemption provisions. If the preemption rights are found in the company's Articles of Association, it might just be a case of simply passing a special resolution at the same time as passing the board meeting or board decisions to approve the sale of the shares to you as a buyer. And those special resolutions would specify simply that you're disapplying the preemption rights in the articles. Thirdly, you'll want to look for other restrictions on share transfers. So beyond preemption rights, there may be other restrictions on the transfer of shares. Some Articles of Association require board approval before the shares can be transferred. For example, the vast majority of Articles of Association require that there is a board meeting and a board approval is given to the transfer of shares. So you'll need the directors of the company to also be on board with you becoming the new owner of those shares. Others may state that a director who is also a shareholder cannot approve the sale of his own shares to someone else because, for example, of a conflict of interest. If that's the case, then again, we'll need to make sure that either the conflict of interest provisions are disapplied by special resolution, or there are enough directors present at the meeting to still form a quorum, meaning there are enough directors present for decisions to be validly made, even if the conflicted director is not counted towards the quorum. So in short, or in summary, we'll need to understand what are the hoops that we need to jump through, and of course, make sure that we properly jump through those hoops as detailed in the relevant documentation.